Hello, everyone. Welcome to our Chatting with Charlie EB-5 Investor Outlook. Today is October 24th, 2023, and it is a pleasure to have you here. My name is Joey Barnett, and I am a partner at WR Immigration. Pleasure to have you join in today, whether you're here live or whether you're joining us on YouTube after we post it. We had over 280 people register for this, so we're going to let folks flow in before we really get started. And it's a very exciting time in EB-5 as more data is released, more guidance from the Department of State and from USCIS is released as it relates to implementation of the EB-5 Reform and Integrity Act. And that's what we're going to be talking about today. Of course, I am joined with Mr. Charlie Oppenheim, the director of our visa consulting, who used to work for the Department of State and spent decades drafting the monthly visa bulletins. Charlie, great to see you.
Hello, it's great to be here.
And as always, we have our legal disclaimer. This doesn't constitute legal advice. It's for informational purposes only. But we'd be happy to give legal advice. Just holler. At the end of the presentation, there will be my email, but you can also just Google us, wolfstorf.com, and click contact, and we would be happy to answer any of your questions. All right, the participants continue to flow in. WR Immigration, we are one of the top U.S. law firms related solely to immigration. We have 9 offices around the United States and global, and over 180 staff members. We pride ourselves on our superior service and our innovative solutions. And we have a large EB-5 practice. We have been doing this for decades. We have filed probably up to around 5,000 of these EB-5 applications, and we are considered the best of the best. So thank you all very much for joining us. And here's our roadmap for today. We're going to be talking, of course, about the Visa Bulletin. We're going to be talking about some information that we got from the Department of State on EB-5 visa number use for the past fiscal year, 2023, and this current fiscal year, 2024. We're going to be talking about, we're going to get actually a very unique perspective from Charlie about what he would be doing if he was directing the Department of State as it relates to these Form I-526E approvals. It's a unique perspective, which I don't think anybody else will has any sense of besides Charlie, so it's going to be really great. And then we're going to talk briefly about the new guidance from USCIS that came in this month related to sustainment and regional center compliance. But before we get going to the Visa Bulletin, it is almost Halloween. Charlie, what are you doing for Halloween? Who are you dressing up as?
One of the Paw Patrol
Oh, you're going to be
people.
Marshall, aren't you?
Yes, grandchildren are going to be all Paw Patrol, and their parents are Mayor Humdinger, etc. So
Excited. You'll have to share pictures with us in the November one,
yes,
so we can have memes of you going through Twitter or X or whatever they call it these days. All right, so let's get right to it. This is the November 2023 Chart A for EB-5 only. There really wasn't movement in Chart A. So my first question to you, Charlie, is what does that signal to you if there isn't movement in Chart A?
I wouldn't be concerned with that. I think that what the State Department did is for the month of November, just held to see what the initial demand is going to be in October. Then when they get ready to set the December dates, they'll have an idea and they can start advancing the dates for December. But I would expect some December movement in both China and India and for those dates.
So in last month's Visa Bulletin, they did advance both China and India forward to stimulate that demand. And what you're saying is that for November, the Department of State is sort of waiting to see what demand actually materializes?
Right, because they set the November dates in early at the beginning of October, so they hadn't had any time to see what the effect of the October dates were. So now they'll have had the most, by the time they set the December dates, they'll have had all of October to see what effect that those movements had, and then they'll know whether they can go ahead and start moving the dates more for December.
Got it. And so, yeah, you mentioned this was released early in October. I think it was October 3rd. Generally, it's released maybe a week or so later. Why do you think it was released so early this month?
I do. You're exactly correct. Normally, I would shoot for making the determination and of the dates on the 8th. But I think that the State Department already knew what they were going to do for November for both the family employment and all these dates. They already knew what they were going to do for November, and that's why they were able to pull the trigger on the 3rd and then get the visa bulletin through the clearance process, so it would be posted much earlier. So again, I think that they'd set the dates for October and at a point, and then they wanted to see what effect they had.
Perfect. And let's move to chart B. And we already have our first question. It's a great question. So chart B um, is what USCIS is allowing those in the United States to use to file an adjustment of status. And if you compare chart B to chart A, you'll see that chart B is much more into the future. It gives the opportunity for those who are in the United States and who are eligible to file for an adjustment of status. So for example, an Indian EB-5 investor who filed in November of 2019 could file an adjustment of status today, even if their I-526 has not yet been approved. That's one of the changes that came with the EB-5 Reform and Integrity Act. And the first question that we have here, and I should have mentioned at the top that I am inviting questions. Please feel free to use the chat or the Q&A that we have with Zoom. But Charlie, I guess the first question that we have is, how long do you think USCIS will allow adjustment of status applicants to use chart B?
That's hard to say. In recent years, they've been allowing it until February or March. Uh, Ideally, they would continue to do that this year, but I would advise anybody that is actively pursuing a case to do their filing as quickly as possible, so that if immigration were to decide to only honor the Chart A, you could have already done your filing.
And that matters mostly for those who are in the unreserved category, because for those who are in the reserve category, at least as of now, and we'll talk about it, it's current, what under chart A or chart B. So if you have a pending EB-5 case before the RIA was enacted and you're in that unreserved category, I completely agree with you, Charlie. There's no time to waste. File it now before they potentially only allow chart A to be used. The other big news that came out recently that relates to chart B and adjustment of status is that those interim benefits that you get, the employment authorization document and the advanced parole, those interim benefits that you have during the time in which the adjustment of status application is pending, and that will remain pending until the underlying I-526 is approved. But those right now are being issued in 5-year increments. And we've had clients receive 5-year EADs. That's amazing. And we're seeing and hearing reports as well about 5-year advanced parole approvals as well. So there would be no need to file for extensions. And that's one of the administrative, I guess, remedies that USCIS has created based on kind of I would say, the delays related to EAD and advanced parole approval. So let me see if I have any other questions about the visa bulletin. What is the expected chart A date for Indians by fiscal year, judging chart B April 2022? I'm not sure I understand that question, but what we've said in, I think what they're getting at is, Charlie, do you anticipate chart A for India and for China advancing? And if
Yeah,
so, how much do you see it advancing, if you can
uh,
estimate?
yeah, the chart B dates indicate where the State Department believes the chart A dates will be in September, in theory. So I would expect that the both the China and India dates will be advancing uh, throughout the year. I think that maybe the China date could advance up to 6 weeks or so per month, and the India date could advance maybe up to 2 months or so. It's important to remember that for specifically for India, that it was current, the category was current in fiscal 2022, and for fiscal 2023, for a full 5 months, the date was out to November 8th of 2019. So in theory, most of the demand with early dates should have been processed during those 2 years. And that's why I think that the state has put out for India the 1 April 22 date for application, because they need to stimulate more demand to use the available numbers in fiscal 2024. And the same reason for China. The China date was as late as December 22nd of 2015 last year. And so I believe they're going to have to, with the January 1, 2017 date, they want to stimulate demand. And that's where they think the date should be in September.
Well, I'm hopeful that that happens, and that would be wonderful if they were able to get through all of 2016. And what we're going to be talking about, and I think that really has to go with consular capacity, right? I mean, and how quickly they're able to actually issue visas at the U.S. consulate in Guangzhou.
Correct. And that will be the kind of the wild card on the movement, the processing capacity, and that hopefully things will stay normal for Guangzhou processing wise.
Well, that leads us to our next slide, where we're going to talk about some updates from the Department of State that were shared with IIUSA earlier this month, or potentially at the end of last month. IIUSA is the EB-5 Regional Center Trade Association, and they were able to schedule a call with Charlie's old office, and we were able to get some data, and I wanted to share that with you all. And pretty much what they said was that, you know, there's the reserve visas and the unreserved visas based on the Reform and Integrity Act. And none of the reserve visa numbers were used in fiscal year 2023. Of the unreserved visas, it seems like actually that the total issuance may actually exceed the annual limit. And the data that they shared was that, you know, over 8,300 of these were issued by consulates and embassies abroad, and close to another 1,500 of them were used through adjustment of status by USCIS. So my first question to you, Charlie, is does the fact that they exceeded the limit in fiscal year 2023, does that impact any sort of processing for this current fiscal year?
No, there's absolutely no impact on 2024 processing. The Immigration and Nationality Act allows you to make reasonable estimates when making the determination of the dates, and therefore, just as in this time, more numbers were used, often fewer numbers are used. So there is no negative impact for 2024.
Okay, that's good. That's good to hear. And they also reported that there would be right around 160,000 employment-based visa numbers in fiscal year 2024. That was right around what we had previously estimated. And that means that, let's just say if it's 160K, that there would be a new pool of 11,360 EB-5 numbers that were that came into existence on October 1st. And the overall theme that I want to um, demonstrate here, and what we're going to get into in these next couple slides, is that there are so many visas available for EB-5 in fiscal year 2024. I think actually more than ever before because of these carryover provisions. And we're going to look at the numbers in particular for the reserve visas, and there's over 8,000 of them. And what that means is that there is such a large supply of these visa numbers that it's unlikely that all of those will get used, in particular because USCIS needs to approve the petitions, and then they need to be finalized and become documentarily qualified. All of that would need to happen, and it's unlikely that we will see that happen in the next 11 months for those 8,000 visas. And I know there are per country caps and things like that, but Charlie, when you just see those overall numbers, and we're going to get to them, I mean, what does that tell you about the possibility of a final action date in the reserve visa categories? Do you still think that it's unlikely that we'll see anything until at least this next summer?
Yes, I think that because of the amount of petitions that need to be approved, then they need to move to the processing stage where numbers would actually be used. I think it's extremely unlikely that there will be a need for a final action date in the reserved preferences this fiscal year. And if that were to happen, it would not be until late in the summer.
And so for prospective investors who are thinking about doing EB-5, this is the time to act. You want to file before any sort of final action date is imposed. And as we'll see, is that because of these carryover visas, there's a large supply, but as those visa numbers get used in this fiscal year and in future fiscal years, there's going to be less of those carryovers, and there's going to be potentially more likely of a final action date earlier in a fiscal year. I'm part of the ALA EB-5 committee. That's the American Immigration Lawyer Association. And we asked this question, we asked this question to the Department of State through our liaison. And it really was about making sure that the numbers that carry over do not go wasted. And pretty much what they had indicated is that whenever there is a carryover, they will use those visas first before using the regularly allocated visas. And Charlie, why is that good news?
It's excellent news because there are so many carryover numbers. If they are used first, those numbers, if they're not used, they disappear. They're only available for use during 2024. So therefore, by state saying they will use those carryover numbers first before they tap into the pool of original fiscal 2024 numbers, that is great, because that way, if any of those 2024 reserve numbers are not used, they would then carry over for 2025 use. So that by them agreeing that they are going to do this is very, very good news for the industry.
And what about for the unreserved category?
The unreserved category is able to use any of the reserved any of the numbers that were carried over and not used last year, so that it's going to increase the unreserved limit to a very nice high total.
And that's what we have on this slide right here. And this shows for fiscal year 2022, 2023, and 2024, the different visa numbers and availability. And I got to give a shout out to IIUSA, and particular Lee, who Charlie, you and I have done webinars and panels with in the past. But he prepared a chart just like this that we sort of copied. So thank you, Lee, for letting us take your great work. And what this is pretty much saying is that there were 4,400 reserved visas in fiscal year 2023. None of those were used, said the Department of State. And so those get carried over again. And so that's why they're in that blue in the fiscal year 2024 row. And when you add those up, the blue and I guess I should say the gray, that's where you get that 8,113. That's how many reserved visa numbers are available in fiscal year 2024. That's assuming that we have 160 of a worldwide level for all employment based. Likewise, they mentioned there were none of the 6,396 reserved visas from fiscal year 2022. Well, none of those were used in fiscal year 2023, so those are added to the unreserved pool. And when you add that up to the 7,724 that we see in that, I should say, fourth column, that's where we get the 14,120. And so overall, there's over, based on this estimate, there's over 22,000 EB-5 visa numbers that are available for use. And, that has a great opportunity to reduce the visa backlog, in particular for Chinese and who filed in 2015, 16. And it also gives some peace of mind to current investors that there will be no final action date because that reserve visa number is so high. Let me ask you this, Charlie, because it's something I get asked often. So of these, I'm looking at the 7,724 unreserved. If those aren't used in fiscal year 2024, those could be wasted, right? Those could fall up for use to EB1.
Correct.
Yeah. So there still is that possibility. But what at least it seems like from the Department of State's comments previously is that it doesn't look like there's going to be many wasted visas in fiscal year 2023. Is that how you read it as well, Charlie?
Yeah, I think that this is going to potentially be a banner year. As the chart shows, this is going to be the highest employment fifth preference combined limit that there has ever been. So this will provide a great opportunity for the unreserved cases to be addressed primarily for China and India, and a lot of the reserved cases that are able to be finalized. And it would be good for as many of the reserved cases to be processed as possible this year, because then it will lessen the need for those demand with early dates going into 2025. So this is a great year. Hopefully that the state will be able to maximize number use by having Guangzhou process at high levels throughout the year.
Yeah, that kind of just was going to get me to my next point. It really, and we mentioned this before, it comes down to the capacity of the consulates to issue, right? That's really where there is the bottleneck at this point.
Yes.
And
And one of the good things is with applicants being able to file for adjustment of status, that will provide a good opportunity for people to use numbers as well.
exactly, that was actually going to be my next question to
Yeah.
you is I was actually really surprised to see that there was only 1,500 adjustment of status numbers used through adjustment of status. Maybe it's just because the processing times haven't gone through, but I do expect that number to go up significantly as more folks take advantage of the ability to file concurrently with an I-526E. All right, so we spoke about this next issue during last month's webinar, and this is one of the I-526E approval notices that our firm received in September. And this was for somebody who invested in a rural EB-5 project that had an I-956F approved. It was an Indian national in the United States on an H-1B visa, stuck in the EB-2, EB-3 visa backlog, and they decided to move forward with EB-5 to take a more proactive approach to their immigration journey. And we were able to get their I-526 approved in just about 3.5 months without an RFE. But this was the first time that we had ever really seen one of these I-526E approval notices. And so on this approval notice in the lower right, you'll see that it says reserved, rural, and then it also says unreserved. And so, you know, it's interesting because this individual filed in a reserved rural category. And so their question is, well, what does this unreserved label mean here? You know, Charlie, you have a unique perspective working for the Department of State. You know, what does this mean to the Department of State? Are they going to be in two visa categories? Is that how it would work, or something separate?
No, what this is going to mean, unless things have changed since I've departed, the State Department can only have an applicant listed in one preference category. So this, to me, means that the National Visa Center is going to have to contact applicants who had a petition like this, who are processing overseas, and say, which of the categories do you want to be processed in? Do you want to be processed in the unreserved or the reserved? Because state does not have the ability to track them in each. And if they were to do so, it potentially could slow things up because the state would be considering the same applicant in both unreserved and reserved categories when making the determination of the dates. So again, I believe state is going to have to notify the applicant to tell and take time there to wait for the applicant to respond before NVC can proceed with their case.
Meaning you're saying that NVC will be asking applicants to choose which category they intend to be in, the reserved or the unreserved?
That is my belief, what will have to happen.
Okay. Is there a way that NVC could potentially process these without having to go that route and take that additional time? Is there something that you would advise them on, or how would you advise them on that?
Yeah, and first I'll give two items as background. In the family sponsored categories, applicants in the family F2B category, sons and daughters of legal permanent residents, once they turn 21, they are converted to a family first preference if they're unmarried. But there's an established policy which allows those applicants who have been transferred to F1 to notify the National Visa Center that they would prefer to stay in the F2B processing line if that is more advantageous based on the final action dates. So when I talk, I'm going to reference transferring the case. And that's what I mean is this policy with F1 and F2B applicants being able to transfer their processing between categories, depending on which is more advantageous. And I'm going to use the term pot is how I would describe the line in which the demand is going to be for State Department's numerical control purposes. And to avoid having to take time for NVC to notify the applicants and say, which category do you want to be processed, and the applicant to get back, I believe that it would be a good idea to have all rest of world applicants who have this dual selection process have all of the rest of world applicants put into the unreserved pot, and they could use the established category code of RU that's listed here. And the reason I say this, there's going to be plenty of unreserved numbers available for use by the rest of world applicants for the foreseeable future. The per country limit in the unreserved category is going to be much higher for the rest of world applicants. So I believe that they should be parked in that unreserved. Then, if at any point in the future it became more advantageous for those applicants to be processed in the reserved category, then at that time the applicant could notify the National Visa Center and say, I would prefer to my case now to be processed in the reserved category. And since they're identified as RU, it would be very easy for them to be transferred. And then my suggestion would be for all Chinese and Indian applicants to be put into the reserved pot using the code RR. And the reason I say this is their 2023 or later priority date provides absolutely no benefit that I can think of under the unreserved annual limit. And there's going to be plenty of reserved numbers available for use by such applicants for the foreseeable future. And this path will provide a more realistic wait time for applicants with the Chinese and Indian applicants with 2023 and later priority dates. Then if it were ever to be more advantageous for those Chinese or Indian applicants to be processed in unreserved, then they could switch to the unreserved category. And there are some arguments against doing this, but I believe that there is no negative impact on the rest of world applicants if they're processed in the unreserved processing line. The one argument for doing so that it is going to result in fewer numbers available in unreserved to address the China backlog. But again, because of the per country limits, I don't think this action is going to negatively impact the Indian applicants because otherwise unused numbers unreserved would go to China. And then the one thing is, some might argue also that putting the rest of the world into the unreserved pot means that more Chinese and Indian applicants are going to be processed in the reserved categories. And that's true. It does, but it would address the fact that Chinese applicants were negatively impacted in the early years of the EB-5 program by the extremely slow processing of their petitions. So I think this kind of addresses two problems. It's going to maximize number use in the unreserved and reserved categories, which is congressional intent to maximize number use. And I don't believe any applicants are negatively impacted by this.
Got it. Got it. Okay, so in that sense, then we're going to have to kind of wait and see how the Department of State responds once a fee bill is issued. I mean, that's going to be sort of the timing in which we're going to be seeing how they're going to be acting and what they're going to be doing.
Yeah, and again, under my plan, automatically putting them in, it speeds up the process because people are going to we're losing time now. This petition, the information could have already gone out to the applicant saying, and at the time when they're notifying, they could go ahead and still notify the applicant, say the rest of world applicants, for example, and say, hey, we've put you into the unreserved category. If you don't really want to be there, let us know and we will switch your case at this time. So it speeds up the process. Otherwise, there's going to be potentially lengthy delays, which will impact number use this year.
Does the fact that we're even having this discussion show that there hasn't been as much coordination between USCIS and the Department of State as one might expect when implementing the new law, or is this sort of just the normal sort of growing pains of implementation?
I think it does. It is growing pains, but I believe that the Immigration Service should have been able to notify state that they were going to be having this dual listing on the petitions so that state could be prepared for, acting immediately. For example, I don't know if for this applicant, have you all received anything from state yet indicating, asking? So my guess is no. And the fact that this petition was, done back in September, uh, again, it shows that timing is everything,
Yeah.
as we've seen. And this, we're losing time with this action. It should have already been identified and a plan laid out.
Yeah, one of the more frustrating things that my clients deal with is once your I-526 has been approved and you're abroad, it's waiting for that case to be transferred to NVC so that they can issue the fee bill, so that we can submit the documents and get you ready for a consulate interview. Right now, that process seems to be taking longer for EB-5 than for any other uh, immigration category. It takes around like 4, 5, 6 months for them to transfer the case from IPO to NVC. And we do follow-ups all the time with NVC. Hey, have you received this application? No, we haven't received it yet from IPO. Follow up with IPO. Hey, IPO, NVC hasn't said they've received it. This was approved 2 months ago. Can you please forward it? And then we get back a boilerplate response saying, yeah, thank you for contacting IPO customer service. Please stand in queue and we'll respond to you as soon as we can. And then 2 months later, we have to do the same thing. So it's this is one of those places where I keep on using the term bottleneck, but this is a bottleneck right now. And I think if they were able to push those cases to NVC faster, then more likely that these visa numbers are going to be used in this fiscal year, right? The longer it takes to the delay for them to get to NVC, the less likely that they're going to be scheduled in that same fiscal year. That's one of the things that really bugs me. And they've even admitted in USCIS liaisons through AILA that all they need to do is send an email. And for whatever reason, it's going way slower than anybody would have wanted to.
Yeah. And again, Joey, on my plan of moving the rest of world applicants automatically, it avoids that time, but it also maximizes number use, because if, for example, Guangzhou is facing processing limitations on staffing, etc., then these rest of world cases could use more of the numbers under this year's annual limit.
Right.
So that would be a tremendous benefit, maximizing number use, because you wouldn't not have to be dependent solely on China to crank out the high volume of numbers. And
Yep.
and those numbers would not be competing for reserve numbers in the future. So it's gotta, in my opinion, it is a win-win process. If you just go ahead and automatically assign the people, the rest of the world and the Chinese up front, and notify them, we've done this. If you don't like it, tell us and we'll switch you to the other.
Well, I hope the Department of State is listening to this webinar and reaches out to you, Charlie, so you can help give your wonderful insight on how to make things a little bit better. Before I go on to these new USCIS guidance, there is a question here that I thought in our Q&A that goes back to chart B, and I just thought that would be good, Charlie, for you to answer. He goes, if chart B is where they expect chart A to be, by September of 2024, does that mean chart B is unlikely to move until next October?
No, what state did in consultation with USCIS, they would have determined these chart B dates for any of the categories, employment first, second, third, any of them. So they will continually review and see how incoming filings and number use is in comparison with their estimated use, and they could potentially advance these dates at any point during the course of the year. The one issue would be is if Immigration Service has shut off the use of Chart B, then that could impact, what would be done later on. But again, it's possible that they could advance the dates. My guess, it is probably unlikely, because I'm pretty sure that they would have done these so that because the people have to file and it's still going to take time, months and months before their case comes to the process, final action stage.
Right, right. Um, Here's another question that you may know off the top of your head. This quarterly limit that was mentioned in the October Visa Bulletin, the 27%. I know it's in the INA. I don't know which specific section, but it's in the INA. That's how that quarterly limit is established. So that was another question that we have here. Is how can we find data about I-485 pending by country and category? Unfortunately, they don't provide this information on their own, USCIS. That would have to be something that would be subject to a Freedom of Information Act request and potentially litigation if they don't respond, because those FOIA requests can take a long time. I know there's a lot of EB-5 groups out there that are doing FOIAs on this type of data that would provide us insight as to, wait times and things like that. And I believe they're working through those, but I don't have that data yet. If I ever get it, it certainly would be part of our discussion in one of these webinars. All right, so those are the questions that we have. We only have about 10-15 minutes left, and I did want to talk a little bit about these new USCIS guidance. But please, if you do have any questions to Charlie, this would be the time to write them in the Q&A so that we can get to them before our time is up. So the EB-5 Reform and Integrity Act created a whole new framework for EB-5, and implementation of the RIA has been very much stop and go, and it has been very frustrating, to be perfectly honest, as someone who is trying to advise regional centers and immigrant investors on what the requirements are. For example, one of the big questions was, well, how long does my money actually need to be at risk? And the RIA changed that. But we never got any confirmation that how USCIS was going to interpret it. Well, until this month. And this month they indicated that there is a new sustainment period for investors who file after the Reform and Integrity Act was implemented. And what they say is that it's a 2-year period starting from the date that the job creating entity, the entity most responsible to job creation, gets the funds. And what they say in their question and answer, which relates to their policy guidance, is that it's even possible to get your money back, to meet the sustainment requirement and get your money back even before your I-526E is approved. And what this has done is it has pretty much destroyed any need for redeployment that was created because of visa backlogs, which I think is probably a good thing for EB-5 investors. But it raises a host of legal issues that just honestly haven't been worked through. For example, there is this new legal requirement, but what matters really is your investment contract and the actual terms of the project that are invested in. So the question becomes well, are these project contracts, are the projects and the developments, is the market going to change for EB-5? And we've started to see some regional centers, yes, do just that. They are reducing that investment period. But even on a more, I guess, technical point is that the regulations, 8 CFR 216.6, which relate to I-829 processing, they still state that the money must be sustained for 2 years of conditional green card status. And that's actually still the case for pre-RIA investors. And so they need to update their regulations so that they are consistent with USCIS's interpretation of the INA. RIA investors, and there need to be regulations as it relates to post-RIA investors. That is something that USCIS and the Department of Homeland Security need to get working on. There's a number of places in the RIA where they're supposed to do rulemaking. They haven't done it. Like, for example, they were supposed to do a fee study within 1 year of an enactment so that they can figure out how much to increase the filing fees so that they can adjudicate these in a timely manner. That hasn't been done. They were supposed to do rulemaking as it relates to redeployment. That hasn't been done. They were supposed to do rulemaking as it relates to ownership of regional centers and foreign involvement in regional centers. That hasn't been done. And so what they're doing is they're putting out this interpretive guidance that they say isn't even binding on USCIS adjudicators, that use terms like may and can, and it's very hard to advise when there are such permissive terms, and overall, I think USCIS's head is in the right direction. I think it's a good thing that they're potentially reducing the sustainment period for post-RIA investors, but it's still the manner in which it's being executed that needs to change. And I think that starts with actually having more meaningful engagement with EB-5 stakeholders. Now, next week, they just sent out an email yesterday, maybe you guys got it, is that they're doing a joint session on Monday with the USCIS ombudsman. That's at 11 o'clock. And there is no registration to do it. There's just a link. So you guys should definitely type in, if you didn't get that email, USCIS Ombudsman EB-5, stakeholder, and so that you can find the link to register to see how USCIS is going to respond. USCIS has really only had one public meeting since the RIA was put together, and it's been, over 18 months since the RIA came out. So this will be the second time that USCIS is speaking publicly. And we need to know what they're going to say. I'm definitely going to be there. I think everyone in the EB-5 world is going to be listening in to see what their thoughts are with this new policy. The other thing that they did was they updated their policy regarding regional center terminations and the impact on good faith investors. And this is a good thing overall. Pretty much what they're saying is that there are situations where regional centers who were in existence before the RIA was enacted no longer want to be, right? There's too much, but they also want to take care of their investors, and they want to make sure that their investors go through the EB-5 process. And previously, if a regional center was terminated before an investor obtained conditional permanent residency, then that was considered a material change, and that would cause someone's case to not be able to move forward. Now what they're saying is that if there's a regional center termination for pure administrative noncompliance, well, actually, you can still count the indirect jobs that were created, even though you were associated that was associated with the regional center designation, notwithstanding the subsequent termination. Now, the big problem is that they haven't defined what administrative noncompliance is. Does that mean just not paying the EB-5 integrity fee? Does that mean not filing the I-956G? Does it mean not filing the I-956? We don't know. And so this is one of those gray areas right now. My advice for regional centers who continue to want to sponsor EB-5 projects moving forward is certainly pay your EB-5 integrity fees for last year and for this year. File your I-956Gs. Those are the annual certificates that you of information that you submit showing what has happened with each project that has been sponsored under the regional center. And even though they haven't put a requirement on timing for this, I'd file the I-956 as an amendment, as showing that you are going to be compliant with the RIA. And the reason why I say this is it appears that they will not be approving an I-956F, which is a specific project approval application, until they have approved the regional center designation. That's at least what the flow chart seems to indicate in their question and answer. And I didn't pull that up, but there's a flow chart in their Q&A that talks specifically about this. Now, again, there is no requirement for it, but it's what I'm advising my clients is make sure you're going through these administrative steps to ensure that your regional center is in good standing in USCIS's eyes. Okay, we have a few more questions that came up, and we have, let's see here. I don't know, Charlie, if you can even answer this, but do you have any? Do you know if the person who took over your job, if they're going to be doing kind of like a monthly program that you used to do with Department of State? Do you have any idea? I mean, I don't know how much you actually know what's going on in the inner workings. Is that something that you think is on their agenda to do? I think a lot of people appreciated that. Oh, you're muted. Yeah. Sorry about that.
Sorry. I do not know. That
Yeah.
would most likely be a decision in the press office, might be thinking of something like that, or the consular affairs front office, but I have no idea if they would be doing that at this time.
Here's another question. Do you think there will be a lawsuit to challenge the post-RIA sustainment period? Well, to challenge it, there would need to be some sort of action that is taken. I guess you could argue it is not interpretive guidance, it's substantive guidance and should have gone through APA rulemaking. And potentially there could be a claim of action there. And, that would be a very, very interesting lawsuit. I'm not entirely sure how a court would rule on that. And I do know that USCIS has sort of already thought about that because they put their response to it in the Q&A. So do I think there's going to be one? Probably, just because it's EB-5 and there's a lot of money at stake, and people who want to make sure that they're doing things right are willing to pay to litigate to get that answer. Let's see here. In previous recordings, Charlie has mentioned issues about getting data from USCIS about pending adjustments. How are they able to set the dates to outdated information? I'm not sure I understand that one. Charlie, do you have any idea what they're really asking about there? Is it if are you setting the final action date or the date for filing based on how many pending adjustments there are?
At the beginning of each month, when I was chief, the Immigration Service would provide me with a report which indicated the amount of cases which they had pending at their national benefits center, how many cases had already been forwarded at the time to district or service center offices for final action. That information, combined with the information reported by the National Visa Center on the amount of applicants who were documentarily qualified overseas, was used in the determination of the monthly dates. So we'd look at that information, and the USCIS information was up to date as of the time they forwarded to me. It was a very nice report, and they did a great job on that. And then they would also provide estimates, because sometimes they may not know how quickly the cases would be processed and how many new people might be coming and getting into the quote pipeline to be processed. I think the tricky thing is the data on which they are making their estimates, and the rate at which people file, that can cause problems sometimes.
Got it. Got it. All right, it looks like our final question that we have today is whether writ of mandamus is a good tool for I-526 processing. The answer is it depends on when you filed, but it's something that we have a lot of experience on, and I would be happy to help. So, Vilas, please feel free to reach out to me, and I'm happy to consult with you on that. All right, I think that's it. Here is my email address. It's jbarnett@wolfstorf.com. I want to thank you all for listening in. Please also remember to register for tomorrow's webinar that Charlie's doing, where he's going to be talking about the rest of the Visa Bulletin with other partners at our law firm. And Charlie, thank you so very much for your time here. And I hope you guys all learned something today. So thank you. Thank you for attending.